you start, Hugo, I'll just like to introduce you and this Earth Rights conversation today. And I am Pella Thiel. I'm from Rights of Nature, Sweden, and I will be hosting this. And we are very happy in Rights of Nature Sweden to be part of the global Rights of Nature community of practice. And we think that there's a lot of knowledge and experience in this community. So we have really great opportunities to share and learn together. And today we're really honored to have you as our guest, Hugo Echeverría, Ecuadorian attorney and doctor of jurisprudence with over 17 years practice in environmental law. And you are a real pioneer working with Rights of Nature. You have been studying the recognition of rights of nature and its effects on law enforcement since 2007. And as you all probably know, Ecuador is widely recognized as a rights of nature pioneer. So this year is celebrating 10 years with nature as a subject of constitutional rights. And that might not be much in legal terms, but it's enough time to preliminarily assess what's happened to the enforcement of those rights. And Hugo will provide a background and an overview of the Ecuadorian recognition of rights of nature and also focus on the application of these rights in courts. I think Hugo will also make a special reference to rights of nature in a blue context. That's issues related to the ocean and marine wildlife. And of course, we also hope, Hugo, that you might touch upon what happened last week in Colombia, where they made the Colombian Amazon a subject of legal rights. And Hugo will speak for more or less 40 minutes. And after that, we will have the opportunity to make questions to you. And I think it would be really nice if you participants also want to share your names and maybe where you come from and something short about your relation to the issue of rights of nature in the chat window that I think you will find, so that we can also have some kind of connection with each other. And before you start your presentation, Hugo, I wonder if you could say something about what led you to this line of work. Why are you a rights of nature lawyer?
Well, thank you for the presentation, Pella, and I am very glad to be able to connect with all of you. I really like talking about rights of nature with anybody who is interested in this topic. What led me to this point, I have to be honest, when the Constitution of Ecuador passed rights of nature, I was quite skeptic, as most of my colleagues still are. But I thought, why do we need rights of nature, or if we already have environmental human rights that can be better enforced? But years later, I was confronted in a case with tough reality. I wanted to, as a lawyer, I wanted to be part of a case about illegal fisheries of sharks, and I could not. I simply could not, because the law won't accept participation of anybody that is not the state. Officially, the state prosecutes infractors of illegal fisheries. So what happened to me is that I went to the court. I asked for a hearing with the judge, and the judge told me that if I was not the state prosecutor, nor the environmental authority, or the shark himself, I was not able to be part of the case. So then this reality invited me to check the constitutional provisions on rights of nature in order to see what can I do, not from an environmental perspective, not from a legal perspective, but from a rights of nature perspective. And long story short, I was able to submit what we call an amicus curiae on behalf of the sharks. That is a document that explains why the sharks are important in cases like this, and what should be the role of the state, of specifically the judicial system, in asserting rights of nature in cases, in shark finning cases like this one. So this is my story, and this is why I ended up not only studying the rights of nature, but actually exploring the legal nature of rights, of these rights. You know, this is what I have been doing for the past years, exploring possibilities of concrete application in real cases, in specific cases. Hello?
Oh, sorry, I muted myself. Wow, thank you, great. And when courts meet the wild, that's such a fantastic headline. So please continue with your presentation, Hugo, and I would just like to remind people to please share who you are in the chat that Marie did. Okay, Hugo, go ahead.
Oh, I go ahead. Okay. Before we go ahead, could you explain or send instructions on? I don't see you, and I don't see myself, so I'm not sure if you are seeing me. Can you see me?
We see you. You're looking good.
Okay.
I think you might have an icon in the upper right corner of the Zoom window where you can switch so that you can see us.
Yeah, is there I have opened several links, but I don't the one of participants, but it's only a list of participants, so I actually can see you. Let me see. Yeah, just allow for a minute to see if I can find something.
But I don't think you will see us because people, they don't show themselves. It's just Robert who's very generous. So we see him, but the other ones are just names.
Oh, all right. Okay. Okay.
Oh, Peder is now saying hi. Yeah.
Let me see. Grabar. Yeah. Okay. Well, let's begin. Let's begin. How many people are there at the moment?
10 people.
Okay, perfect. And I see in the messages that there are 10 people from Sweden, but also from other places.
Yeah, isn't that amazing?
So
we have Robert from Germany and Guillaume, who is in Sweden, but he's French. And then Isidora from the Bolivian embassy in Stockholm. And then Peder and Anna and Susanna, Mariam and Marie from Sweden.
All right, perfect. Well, hello to everyone, and let's begin. In the following 40 minutes, we will address these basic 4 points. Pella asked me to concentrate on cases, which I will, but I wanted to give you a little background on how Ecuador ended up recognizing or acknowledging, that's a better word, rights to nature. And this is where we will begin. As you might know, in 2008, Ecuador adopted a new constitution that actually acknowledges nature as a subject of rights. To date, this is the first and only exercise or the only case in the planet of a constitution having taken this bold step. And I say that bold because law and constitutions are not are founded upon anthropocentric approaches, where the human being is the center of the center of the law and of all the concepts. The Constitution recognizes two specific rights to nature. The right to nature, the right of respect of nature's existence, meaning that we have to respect her life cycles, and the right of restoration, restoration of damaged or of ecosystems damaged by environmental harm. So this is a very first idea that it is important to put in the table, because this is the legal foundation or the legal basis for the for rights of nature in the Ecuadorian Constitution. Before I move on, is my English okay? Do you understand the volume, the speed, everything is okay?
It's perfect. Thank you.
Okay. This happened in 2008, to be more exact, in between 2007 and 2008. There was a constitutional assembly, and the document was validated by referendum. But Ecuador has an interesting history regarding constitutional protection of environmental values. And that history dates back to 1983. And this date is important, 1983, because there was a constitutional reform back then that included and recognized for the first time in history the right of human beings to a healthy environment. So Ecuador is a country which was born in 1830. So centuries later, a decision was made that the environment was important enough to be included in the Constitution. And the way they did it is that they, the right to live in an environment free of pollution. So this happened in 1983. A decade later, in the 90s, specifically in between 1996 and 1998, there was an expansion of this concept, of this constitutional concept, to include a green perspective, meaning that not the environmental rights should not only cover pollution issues, but should specifically cover biodiversity issues. And therefore, we have an ecological perspective was included in the Constitution. So these momentums are important for us to understand the context of recognition of rights of nature in 2008. What I want to show here is that this recognition has a history, has a background, an important background that we need to know. In the screen, I invite you to read the translation of the text in Spanish for you to get a full sense of what the Constitution recognizes to nature. So you see that the right of integral respect includes maintenance and regeneration of life cycles, structure, functions, and processes. So this is really comprehensive approach to nature, and it's very difficult to apply. You know, the Constitution set a very high standard when it comes to rights of nature. I'm not sure we we will be able to ever reach this high standard in concrete cases. And the second right is the right of restoration. What the Constitution wants to say is that restoration means something different than indemnization. Let me explain a little bit. When we see the word restoration in the constitutional context, it means that the focus of reparation is on the ecosystem, is on nature herself. Whereas indemnization means that the reparation benefits human beings, and that is persons that have been affected by environmental damage. So this is important to make the difference. Restoration means reparation of nature herself, and indemnization means reparation of human beings affected by environmental damage. And this second point, to date, has not yet been tested at courts. This is a work in progress. The first point, the first article, the respect, has been a little. That's the topic that has been has started to being applied in specific cases. Pella, should I continue, or I open up a space for questions or observations?
I think that if you make your presentation and people can ask questions when you're done. So I think people are, having a calm time at home. And if you have questions, maybe you can just write them down and save them for when you're finished.
Okay. So let's move on. But yeah. I have shown you the outcome of the constitutional exercise that we had in 2008. But behind the scenes, the main, nature was a main issue of the Constitutional Assembly, of the constitutional debate. And that in itself, it has a value. It had a value because, as you know, environmental matters not always are at the top of the agenda in any way or anywhere. So this was an interesting momentum for environmental matters, without a doubt. And the premise was that the premise or the basis of the debate was that environmental rules and institutions, meaning authority, environmental authority, laws, bylaws, rules, everything that there was, because there, we had, as a country, we had a prior environmental legislation, had not achieved or had not fully achieved the goal of environmental protection. The idea was that, yes, we have a set of laws, we have institutions created to enforce those laws, but not much has happened. On the contrary, we have ever-growing environmental issues related to oil, related to mining, related to logging, pollution, water quality, overfishing, you name it. So what can we do about that? There were two alternatives at stake. The first one, which was the most obvious one, is to better existing environmental legislation, to improve it, to enforce, to strengthen the concept of environmental protection, which was perfectly adaptable with anthropocentric conceptions of law. But there was a second alternative, and that was adopting this idea or borrowing this idea coming from indigenous legal systems, basically the concept of Pachamama and the concept of respecting Pachamama. Pachamama, you know, means Mother Earth. So these were the two alternatives, and the constituents ended up choosing respect to Pachamama. And this is how the concept of rights of nature was included in the new constitution of the country. There is a big difference here that I always like to emphasize. When we talked about respect to Pachamama, we are talking about showing the highest constitutional values that someone, not something, that someone can have, and that it's the concept, the universal concept of mother. So mother is, is a person that deserves, I guess this is universal concept, the best possible level of any value. See, is almost sacred, one might say. So that's respect to somebody as opposed to protection of something. See, then this is very important to differentiate. In Rise of Nature scenario, you show respect to someone, whereas in environmental law scenario, you protect something. So the concept is very different. Now, I like you to I like to propose this for the group. Maybe we can discuss later. Everybody knows that Rise of Nature is founded upon ancestral contributions. More specifically, is an adaptation or is borrowing this wonderful legal concept of indigenous legal systems, Pachamama. But whereas this is the fundamental, the basis of rights of nature, at least in the Ecuadorian experience, it should not be considered as the only one. Because as I told you in the beginning, recognition of rights of nature is also the outcome of several decades of environmental law development and evolution in Ecuador. And elsewhere, just to make an example, in the 80s, in 1982, the United Nations adopted the World Charter for Nature. And basically, this document acknowledges the importance of respecting, the concept of respecting nature, just like the Constitution of Ecuador says, and based upon the idea that we have to respect the intrinsic value of nature as opposed to protect natural or use natural resources. So this is an idea that can also find basis or normative legal basis outside the concept of Pachamama, and this is an advantage because this can be an argument that could be used in order to extend the application of these ideas outside countries like Ecuador, where you have these indigenous legal systems as a basis. I hope I made my argument clear. I just wanted to say that Pachamama is not the only foundation, or should not be regarded as the only foundation, because there are foundations that you can easily track back to international treaties or international instruments. And therefore making this idea more accessible to universal concern or universal or universal application eventually in the future. Before we move on to cases, I just want to let you know that we are all, the people who is following this webinar, we are all enthusiastic about this topic. But the reality, my friend, is that we are a minority. Not even in Ecuador, you have consensus about this, especially among lawyers. This topic is not welcome. It's certainly not welcome because it directly confronts with the idea of human rights. So to date, the leading opinion is that rights of nature, at best, can be seen as a symbol, but with no practical or real application. And in the screen, you see the differences, the main difference. They say that nature is an object of protection, not a subject, that it could not be considered as a subject of rights, because it is a natural resource. It is something there for the use of human beings. Example, Yasuni oil exploitation in Yasuni National Park. That happened whereas rights of nature were already adopted. The second argument is that rights of nature are dangerous because they debilitate, they weakening human rights. And this is a this is a risky argument, because human rights in legal context are the most important, is one of the most important subjects, contemporary subjects, as you know. And the third argument is that rights of nature are not needed, are not necessary, because you can actually reach restoration and you can protect nature using existing environmental anthropocentric legislation. Those who are in favor of rights of nature theories and practices say that nature can be a subject of rights, just like corporations are. So there is not much to think about that. You know, if you grant rights to buildings and corporations, and how can you not grant rights to life, to living beings, such as the components of nature? They also said that rights of nature do not debilitate human rights. To the contrary, they reinforce human rights because they reflect the level of human dignity that humans now are capable to realize and to understand, that not only human beings, but all other living beings can have rights. And this is a really interesting argument set forward by an important judge coming from Argentina, who is now a justice at the Inter-American Court of Human Rights. So we will see in the future how this concept, probably this concept will be applied in the Inter-American human rights system. And finally, the people advocating and lawyers advocating for rights of nature say that they are necessary simply because environmental law have proven to be ineffective. So a new alternative must be opened. And actually, you can see this logic in the recent Atrato River case in Colombia, in two recent decisions. The 2017 Atrato River case, which I refer later on, and in the April 5th decision, just 5 days ago, granting legal personhood to Colombian Amazonia. So basically, that is what the courts have said. You know, environmental law have not fully achieved environmental protection. Therefore, we need to look for an alternative. Is that clear to everybody?
Yes, it's perfectly clear. Very interesting. Thank you. Okay.
Please let me know if I am too technical. Let me know if I need to reformulate the explication.
I mean, it is very clear what you state, but I think we will discuss later, right? So it's matter of just a question of understanding if there is, right?
Okay, perfect. All right.
I mean, it's perfectly understandable what you just explained.
Okay, thank you. because this part can be a little bit confusing and tricky, but I just wanted to make sure that I sent the right, I explained it well to everyone.
Maybe it's just a short question then. What you said is basically you arrived at the conclusion that the current environmental law is ineffective to protect nature, and the conclusion that you got out of this was we need an alternative. Okay. This is basically, you state this. It was like a judgment that it is ineffective what we have, so we need something new. That's basically the concept that you're trying to present.
Yes, well, yes, exactly. Thank you. It's not my concept. Is the concept of those who advocate for rights of nature, and it is a concept that has actually been adopted in 2 recent judicial decisions in Colombia. So it is impressive, because at least from the legal perspective, to conclude that that environmental law has not fully achieved the goal of environmental protection is very big wording. It's basically saying this discipline is not working. Something is happening with it, and and to the point that we need to look for a new alternative that in legal terms is very, very bold, because you are stepping out from the traditional anthropocentric view and going all the way to another perspective, and an ecocentric perspective. So yes, it's interesting to see this phenomenon, and this gets more interesting by the minute, because the ones who are taking these steps are the least expected to take such a bold step. We are not talking about environmental lawyers making these decisions. You are not talking about lawmakers. It's judges. Judges are people who are really far away from environmental matters, because these are people that are concentrated on other matters. These are judges that have no experience on environmental law whatsoever, but nevertheless, they are the ones that at the end of the day are deciding over these cases and have to make decisions. And they are making important decisions in terms that they are the only ones today that are actually saying are explaining to us what rights of nature are, what rights of nature are about. And this is to be honest, as a lawyer, I think this is a really interesting phenomenon, and I will explain why a little bit at the end of the presentation. So, but before we move on, I will leave you with this idea that the ones giving content to rights of nature are judges, not only in Ecuador, but basically elsewhere, in Colombia, in India. The leading voice in rights of nature are the judges. Why is this happening? Because at the end of the day, scholars, academics, they keep talking about whether or not this was a good idea, whether or not this is consistent with general principles of laws, whereas judges are faced with the reality that they have to apply these topics, this subject into real cases. So this is an alternative perspective. Instead of approaching rights of nature from a perspective that I like rights of nature or I don't like rights of nature, they simply apply the law. You have rights of nature in the Constitution, then we should apply it. So it's a pragmatical perspective, if you want to label it in any way. And this is a perspective that, to be honest, I feel very comfortable with it, because a lawyer, I mean, if you find a tool, then you use the tool. So this is a perspective that has helped, certainly helped, giving content to what does it mean, or what is the extent of rights of nature in the Ecuadorian constitution. 10 years later, I mean, this is a very short time for anything in law, but 10 years later, we have had several cases regarding water, regarding rivers, regarding protected areas, and regarding wildlife. We also have had a set of cases that have not gone well regarding mining, for example. But the most important case law regarding rights of nature has been around the subjects that you see in the screen. Well, now we enter to move on and stick within the time frame. There are many cases, well, several cases, not let's not exaggerate, but there are several cases specifically addressing rights of nature. You are, for sure, you are familiar with the Vilcabamba River case, which is a 2011 case that predates the Ganges River case in India and the Atrato River case in Colombia. So I won't be stopping by the Vilcabamba River case, just to mention that this was the first case where nature acted as a plaintiff, and a decision was made under the consideration of rights of nature. I would like to stop for a minute in this BioDigester case, not because it is, well, it is an important case, but the reason I put it here is because this is the first ever case. This case even predates the Vilcabamba River case. This is a 2009 case. It was not drafted as a rights of nature case. It was drafted as an environmental law case, a typical case of pollution. But the judges of the Constitutional Court of Ecuador decided that it was a case about whether or not the construction of a biodigester. By a biodigester is a facility where you take debris, animal debris, and get the methane from it and make it and transform it into biogas. Biogas, yeah. So, but the judges of the Constitution transformed this case into a rights of nature case because of concerns of water management of the plant where this was happening. And by doing so, they argued that as judges and guardians of the Constitution, they have to make sure that not only human beings were okay in this case, but also nature. And specifically, they pointed out to water, because apparently the company running this project was throwing the debris directly to the river, passing nearby. So the court said that they do not, they have to extend their jurisdiction to check what was going on with water disposal. And in order to take that step, they founded their reasoning in rights of nature. So this is the very first case that I wanted to share with you, because seldom is being mentioned, but it is important to do so because it was, you know, the first one opening the door of rights of nature into court. This case, do you see the picture there?
Yes.
Yes, it's a very nice picture.
It's a wonderful picture. And this place holds the tallest mangroves in the world. mangroves that reach up to 60 meters of height. In a normal, a regular mangrove is maybe 3, 4, 5 meters. So these mangroves are huge. And these mangroves are located in an ecological reserve, which is a natural protected area of Ecuador. But because of the international importance of this ecosystem, this site is also a Ramsar site. A Ramsar site is a site protected by international law.
As a wetland.
Exactly. A wetland of international importance. That's the official designation.
What's the name of this forest?
Cayapas Mataje. I can send the website and the link because this place is really impressive. And it is located in the north west part of the country. The park holds 51,000 plus hectares, so it's a reasonable size. And the problem was that within the borders, within the limits of this park, there was a shrimp farm, privately owned. A shrimp farm, do you all understand a shrimp? What a shrimp is? It's like a little lobster.
Yeah.
Okay.
Yes.
So the shrimp farming is an activity that to date is considered as a with high impact, environmental impact. So there was the legal problem was that a shrimp farm should not be inside the borders of a protected area, because a protected area is the land belongs to the state. So how can somebody own land within a protected area and use that land to conduct a an activity with high environmental impact? That was basically the case. The court, what happened was that the environmental authority kicked, sorry, I cannot find a better expression, but kicked the farm out of the reserve. You know, they said, you know, you cannot be here, so your operation is shut down. And the owner of the farm went against the authority in the courts and won. The owner won under the argument that his property rights and his labor rights needed to be recognized. So the judges gave reason to the owner, even though it was clear that this land belonged to the state, and it was also clear that the environmental impact of the activity he conducted was very high and inconsistent with the values of the protected area and Ramsar site. So the National Environmental Authority was not satisfied with that decision and went all the way to the Constitutional Court of the country. Constitutional Court is the top court in any country, and as is the case in Ecuador. And at the court, the point was whether or not the lower judicial decisions were right, because in any of these decisions, rights of nature were even addressed. They were not even mentioned. So judges made up their minds only considering property rights and labor rights, but not considering rights of nature. That was the debate at Constitutional Court. Well, after hearings and all this legal procedure, the court decided what you are seeing in the slide that I will leave you for a few seconds for you to read. So the court said the constitutional court of a country, I like you to think for a minute about this. You know, this is not a lower level judge or an appeal court. This is the top court of Ecuador. It said that the court points out the importance of rights of nature and also acknowledges the duty of the state. See, this language is really, really wonderful. The duty that the state of Ecuador has to promote respect for all the elements that are part of an ecosystem. So the word respect is important here because the court is not saying protecting an object. The court is saying respecting the ecosystem. So it changed the discourse completely. And then the court moved on to say that the constitutional character granted to rights of nature leads to the state's duty to guarantee their effectiveness. See, this is really important because the court ratifies the role of the state in being a guardian of effective application of rights of nature because they are of constitutional hierarchy. This is, I always like to point this out because this is important and this is the reason why the Constitution of Ecuador made a difference in the constitutional system. Because it's, you know, the Constitution is the supreme law of any country, is the most important piece of rules there is in any country. And this excerpt is a clear example of that. You know, the judges set a duty on the state on effectiveness of rights of nature because it is in the Constitution. And then they say, and this is an important quote because it helps understanding a following case that I will also tell you. It says that that duty belongs to the judiciary. You know, they have a specific task to watch over their protection of rights of nature. So this statement is really, at least in legal terms, is really, really powerful. And this is a 2015 decision, so it's fairly recent. Of course, it didn't make the headlines as the Colombian cases have, but nevertheless, the content is really important, and this is why I wanted to share it with you. Moving on, remember the topic of my presentation is blue context. This is why I choose mangroves cases, and now we move on into shark cases, specifically cases happening in the Galapagos Islands. Just a quick note: there have been several cases regarding illegal fisheries or transportation of sharks. I keep a record dating back to 2010, but the one that we will concentrate today in this webinar will be a 2017 case, that is last year, which made headlines all over the planet, and it involved the illegal transportation of 6,223 sharks. They were transported in a vessel through the Galapagos Marine Reserve, that, as you all might know, is also a World Natural Site, a World Heritage Site, declared as such by UNESCO. So this case is a criminal case because illegal transportation of wildlife in Ecuador is considered to be a crime, a criminal infraction. And this was very, very serious because Galapagos is known for having the world's highest concentration of sharks. There you have a map where in your right you will see Ecuador, the continental territory, and on your left, 1,000 kilometers away from the Ecuadorian coast, you see the Galapagos archipelago. So this is where this case took place. As I mentioned, this is an actual picture of what authorities found inside the vessel. This case was about illegal transportation of endangered sharks. So these are sharks that are protected by international treaties, such as CITES and the Convention on Migratory Species, that is very famous in Europe. And the illegal transportation occurred or happening in a natural protected area which is also protected by international treaties, such as the World Heritage Convention. There was a trial, a criminal trial, and a guilty verdict was issued in August 2017. The captain and the crew were convicted to prison, and there was a restoration order on the sum of $6 million and confiscation of the vessel. In the decision, and this is why I want to share the decision. Take a look at what the first level judge said from the very beginning of the case. This is taken out of the first 3 lines of the verdict. Again, we come with this idea that the state have a duty not only to guarantee human rights, that is due process, a fair trial, etc., and which is good, is okay, but also the duty to guarantee effective enjoyment of rights of nature. This is a quote from a judicial decision adopted in Galapagos last year. It is a really powerful statement. You know, to say, for a judge to say that the decision will be made upon human rights protection, but also rights of nature. See? And this is why in Brown, you see at the end of the quote that the judge said that rights of nature and human rights will be the constitutional parameters of this specific judgment. And they were because one part of the decision is all about meeting due process requirements on behalf of the defendants, and the other part is all about establishing legal responsibility of illegal transportation of species that are protected by law and international treaties. And
question.
Yeah.
You said that the accusation in this case was illegal transportation within this marine reserve of natural heritage area. The last picture you showed gave me the impression that it was actually also might have been a case of illegal fishing, in fact, and this would make a big difference, in my opinion, if it's just like a transportation of endangered species in a live state, like live fish, to be later on held in captivity in aquariums or zoos, or if it's illegal fishing by killing these animals in a huge quantity. Or why did you emphasize this aspect of illegal transportation specifically?
Oh, thank you. That's a great question. And the reason you are not going to believe is very simple. it was easier to prove transportation than to prove fishing, because the defendant said that they caught these fish outside Ecuadorian waters. So in order for them to prove otherwise, and the prosecution should have, how can you prove that? And how can you prove where fisheries took place? So it was a really risky way to go if you were to go again on charges of fishing. So they went, and I think it was a brilliant procedural strategy. They went through transportation, which in the criminal code of Ecuador is also an infraction. But that is basically this is a procedural strategic. This was a procedural strategic decision.
Hugo, before you continue, I would just like to note that we have been joined by several people here, and I think we might have a confusion around time, because actually it's now 8 o'clock Central European time here in Sweden. We have now summertime. So if you joined us now, you are very welcome, and we are in the, I think actually Hugo is nearing the end of his presentation, and we will soon have questions. And I just can't resist to note that David Boyd is with us, and I wonder if you are the David Boyd who wrote the very great book on rights of nature that is featuring Hugo in it. So we are very humble and happy to have you here. Is it you?
Yes, it is, and my apologies for joining late. I obviously didn't translate the time correctly.
We are very happy that you're here. Maybe we can have a webinar with you as well soon.
That would be terrific. Thank you.
Great. Thank you. Okay, Hugo, continue.
Well, hello to everyone who have just joined us. You are very welcome, and hello to David. I'm glad you are joining us. I know you are familiar with the Galapagos experience on application of rights of nature. And we were just talking about this 2017 shark case that received worldwide attention. And before I move on to the worldwide perspective, I just want to emphasize on the importance of the judicial decision adopted in that case, the first level judicial decision, because it is the first time that I see a judicial decision saying that, or setting up the borders of the decision, not only on human rights, but also in rights of nature. And not only saying that or stating that, but actually putting that concept into practice. So this decision is very important. The case went to appeal, and there were minor changes in the appeal, but basically the criminal responsibility, legal responsibility remains. And right now the case went all the way to the Supreme Court of Ecuador in legal recourse that we know as casación. So this case will probably, if admitted, this case will probably get a new revision at the Supreme Court of the country sometime this year. And if you like, I will keep you informed, because I am following very closely the developments of this case. In fact, if this case is admitted at the Supreme Court, I am, and this is no one knows that I like to share this with you for the first time. I am seriously considering filing an amicus curiae using Article 71 of the Constitution. Article 71 of the Ecuadorian Constitution says that anybody can request any authority the full enforcement of rights of nature. So let's see what happens. And but I will keep you informed if you like. Well, now it is time to, nearing the end, it is time to check out a bit of worldwide perspective. I know that other presentators of these webinars have already spoken a bit about this perspective. So I just want to mention that New Zealand, India, and Colombia have also made very important contributions to the development of this emerging concept. For time reasons, I will only mention the Colombian case. Colombia have made headlines last year and 5 days ago with two decisions issued by the Constitutional Court of the country and now the Supreme Court of the country, granting legal personhood to a river and to an ecosystem. And before we move on into the details, I just want to let you know, because I know that Colombia worldwide has not, when we talk about Colombia, we often talk about negative aspects. But Colombia the courts in Colombia are very well known in the region, and they enjoy a very high level of reputation, to the point that every single country in South America actually takes a look of the decisions, especially the ones adopted by the Constitutional Court. And what I want to say is that whatever is decided by the Constitutional Court of Colombia enjoys high respect, high legal respect. It's very prestigious. So for a court of that status to actually move on and acknowledge legal personhood to a river is really, really impressive. So this is an idea that I also want to share with you. Maybe not all of you are lawyers, but this is important for you to know. It's not that just any court has moved on forward this concept. It is a quite prestigious court. The Atrato River case is important because what the Constitutional Court said in the Atrato River case is basically that environmental law has failed to offer protection to the river. The river has, the problem with the river is that it's basically a dead river due to illegal mining activities. This river is the third in importance in Colombia. It passes through this gorgeous region of Chocó that has it is a hot spot. And there are people, 500,000 Colombians live along the river. And there are heavy and several, there are very hard medical conditions there, health problems, all sorts of problems. The judges conclude that environmental law has not been able to stop environmental damage. And therefore, the court says that they need to find an alternative, a new concept that will allow the state to actually provide for better standards. And not only that, but provide for illegal mining to stop. And then this is why they raise this argument that they need to take a look of these new less anthropocentric approaches. And they also need to consider that there is people suffering from these environmental problems, and that the river itself or himself is also suffering from this issue. So they conclude that the way to go is giving legal personhood to the Atrato River, and that's what they do. They use an old tool that the civil law provides, and they name or designate a custodian. as a group, there is a group of people from public sector, from private sector, and from and the victims, or the people, the locals themselves, to make sure that the decisions of the court are effectively applied. They also gave a deadline, and gave a specific orders for this problem to be properly addressed. As I'm not a Colombian citizen, nor I live in Colombia, but I have been in contact with people in Colombia in order to find out whether or not this decision is being put into place. And they say that yes, the decision is being put into place. And of course, you are not going to see immediate restoration of a problem that have lasted for decades. But the first momentum after the decision is showing that the orders are being met. So this is a case that we will need to revisit in the near future to see what's going on and to see to what extent this legal concept has been able to make a difference in terms of effective application of environmental standards. Most recently, and this is really recent, this is just 5 days ago, not 5 weeks or 5 months, it's only 5 days, the Supreme Court of the same country, the Supreme Court of Colombia, surprised the world in informing about a decision adopted in a climate change case. So this is the first idea that I want to share, is that this is not a case about rights of nature, because Colombia does not recognizes rights of nature in its constitution. This case is about a group of young people concerned about the effects of climate change in their lives. So this case is better labeled as an intergenerational equity case. So basically they say that they are concerned about the rights of their generation and future generations due to problems related to climate change in Colombia. And what they wanted is for Colombia to take steps, to take action in order to prevent deterioration of the Amazonian basin. And the Supreme Court of the country, the case ended up in the Supreme Court of the country. They say that the petition is valid. So first of all, the court said granted standing, something that is a bit technical, but basically they say that future generations are welcome at courts. If you want to put it in an explanatory manner, that this is not a new concept, but certainly it is new in Colombia. Future generations are welcome to knock the door of courts and ask for justice. And second, that they say that, again, that they adopt the decision of the Atrato River because they think that the only way for the Amazonian issues to be addressed, to be effectively addressed, is moving on towards recognition of legal personhood. And that is what they do. And therefore, they also order a commission to be created to monitor decisions of the Supreme Court. They also give a time frame of 5 months, if I'm not mistaken, for the state and for the state institutions to take action, aiming, and get this, aiming at zero deforestation rate in the Colombian Amazon in the coming years. Zero deforestation rates. So just to conclude, as a lawyer, I cannot, I keep amazing myself watching and seeing these judges, adopting a role of that you don't see it every day. They are actually giving orders And these decisions are better fit if they were made by the ministries of environment, for example. But given the problem that the authorities have not made these decisions, judges are stepping in and are adopting these approaches. Just to conclude, I don't know about you, but the feeling I get is that we are witnessing the emergence of something that will stay, that came to stay. I know that we are a minority in terms of people that study rights of nature. They see it as something anecdotal, something that maybe is a fashion. They see it also in frivolous terms, but what is happening in several parts of the world, I guess they are not exceptions. They are, of course, they are not the rule, but they are indicators that something is happening, and maybe it is time for this idea that emerged in the 70s of rights having nature having rights. Maybe it's time for comeback for good. So maybe we will be witnessing the beginning of several decades of this interesting discussion and debate. And just to conclude, I just want to share this very nice story about this brave jaguar that you see in the slide. Her name is Dijaira. Dijaira is a young jaguar whose mother and herself, they were victims of hunters. She was found with 18 shotgun pellets in her body. She was rescued by locals in the Amazonian Ecuador and taken to a veterinarian hospital in Quito, in the capital of the country. There, doctors made all efforts to save her life, but there was a problem. One of or two of the bullets affected her neurological system, and she was not able. She was alive. She didn't die, but she was not able to walk. So doctors, they were so sad about this that they actually conducted neurosurgery on Dijaira, and now a year later she is ready to go back into the wild. So they gave her, she struggled for her life, but she made it. So it's a very nice message of how that you need to resist, you need to yes, you need to be brave. This is a message that comes from nature herself. Dijaira is a indigenous name that translated into English means brave jaguar. And as I said, this baby jaguar is ready to go back home into the wild as we speak. And with this, I conclude. You have my email address there. I will be, other than, I know we are opening up a discussion at the moment, but I will be happy to keep in contact with you. Thank you.
Thank you so much, Hugo. What a nice conclusion as well. Beautiful. And I think, I don't know, I think you and me might be also confused about time, but we don't have so much time left. I think maybe we can go on for like 20 more minutes or something like that. And since I think that, I mean, even the questions I have, you could spend an hour to try to answer those. And so I think how we should do this is that maybe if you have a question for Hugo, post it in the chat, and then we can all see the questions, because there's a lot of wisdom also in the questions. So even if we don't have time to answer all of those questions now, they can still be food for thought. And as Hugo said, I think he will be pleased to answer them also in other spaces later. So there is one question now from Marie. I hear about tensions reinforcement of nature rights and human rights. Last Earth Rights conversation, I sensed a backlash in the ways indigenous peoples draw on rights of nature to make claims. The word was indigenous rights are more concrete. It would be great to hear your comment.
Could you please go a little deep in the question? I don't understand the last part. I was not present at the last IRC.
Oh, the last Earth Rights conversation. So the last webinar we had was with Michelle Bender. I don't know if that's what Marie is referring to. Maybe you want to explain your question, Marie. Oh, it was with Craig Kaufman. Yeah. So I think he was referring to maybe the development in New Zealand, where indigenous peoples aren't that interested in rights per se, but in a perspective of the world, and maybe that indigenous rights were more concrete than rights of nature. I'm not sure I recognize that. So Marie, I think you need to explain your question. Or we take another one for now.
Oh, I can.
Maybe I understand a little bit the question. I don't know if Marie is here, but if what she meant by a backlash is that actually nature rights may have been used often as a proxy for indigenous rights. So I don't know if we are aware of cases where nature rights were claimed without having maybe indigenous right as a first motive. So but by this, I mean that indigenous rights are really facing enormous difficulties to have their rights recognized. And maybe it's a strategic move to adopt a right of nature framework that may be easier to recognize than indigenous rights. I don't know if that makes sense what I say. But often I have, when I reflected on that, I realized that the last International Tribunal for the Rights of Nature in Bonn last October, all the cases that were presented were actually indigenous rights cases. They were not, strictly speaking, nature rights without any human community injured. There was always a human community that was injured and that was bringing the case.
Thank you. Can you hear me?
Yes.
Yeah. Thank you for the explanation. Well, indeed, if you see in a broader context, indigenous rights and application of indigenous, I mean, in any case, if you have to choose, one can see that indigenous rights are a better option, or have been an option other than rights of nature. And I only have one, a simple answer for that. And that is because rights of nature are the new kids on the block, whereas indigenous rights have more history. So that could be one answer. I mean, if you are a member of an indigenous community and you have to go to court, it's logical for you to choose human rights that have been there for a while. It's a bit risky to choose these novel rights. So there you go. It could be, again, a legal strategy oriented question. But in order to answer there is a deeper question in Marie, and it is about tensions between rights of nature and human rights. And she is right. Like I said, and that tension is well reflected by this idea that rights of nature debilitate human rights. Remember, I told you in one of these slides, this is one of the main arguments that those objecting rights of nature put into the table. That rights of nature debilitate human rights. So this gives you a clear example of that. This topic is not is highly controversial. It's also seen as a bit as a threat in a way. To be honest, I don't understand why it's been seen as something that can create attention. Because at least in the context of the Constitution of Ecuador, rights of nature are designed to be complementary to being applied in connection with human rights.
Yeah, I guess it touches upon a whole worldview of the dichotomy between humans and nature that's sort of in our culture almost. Mm-hmm. So thank you. There is a question from Mariam about the mining cases you mentioned that didn't go as well as the wildlife cases. And I guess maybe we need to have a whole webinar on that because that's a whole issue in its own. But if you could touch upon that, Hugo.
Yes, thank you. Well, at back in 2008, the first movement to put rights of nature into practice was not directed or was not addressing wildlife issues. They rather went, the advocates of rights of nature decided to go against mining program, to use rights of nature against mining cases. And all the cases were lost. There were not many cases, but all the cases, they lose all the cases. Why? Not because they were bad lawyers or anything like that, but the way I see it is that when you approach mining, you find you approach something that is difficult, but because mining is legal. Mining is not an illegal activity. So in order for you to challenge a decision that is legal is very difficult, regardless of the argument that you have. And in my opinion, using rights of nature was not the best option because you were defeated in the first round. And this brought about it was not good for rights of nature, let's put it that way. Because basically what advocates of rights of nature were saying, mining should stop because the Constitution of Ecuador grants rights of nature. And that was not the case. Mining is not illegal. The problem, we all know that mining has high environmental impact, but that is one scenario, and another completely different scenario is to take down an activity that it is legal. So after that, there have been no more cases on mining, on challenging legal mining through rights of nature.
That's very interesting indeed.
Yes, so, many people have the thought that you can stop development with rights of nature, and that's not the case. At least that is not what the Constitution proposes to do. So what the Constitution proposes to do is that you are to develop in the best possible way. In any case, better than sustainable development proposes. That is what is right of nature at the end of the day is all about. And I know this may be surprising to some of you, but that is the real deal. I mean, if you take a closer look of the Ecuadorian Constitution, it is nowhere saying that Ecuador is going to stop the developing or go back to an age where you don't have electricity or anything like that. That's not real.
And that raises an interesting question that Guillaume is posing now. So what if development violates the rights of nature? Because the issue that sort of surfaces, I guess, is that so humans have rights and nature have rights, and then you have to balance those rights to develop in the best possible way. So what if the development, even if it's legal, like the mining operations, if it violates rights of nature?
Yeah, that's a question that I don't have an answer for it at the moment, and I guess that will be the key question for the future, because of course development means changing the natural structures, as the Constitution says. It means affecting life cycles. So this is why I told you that the wording of the Constitution is very, I mean, it gives a lot of trouble, because, I mean, how can you develop without affecting nature? It's sometimes you can't. And what do you do about that? So this is why in 10 years, it's impossible to give an answer for that. But what it can be said is that the Constitution does not close the door for development through using the rights of nature argument. Let's see what happens in future cases. What I can tell you, in order to give a preliminary conclusion on this topic, is that in the Yasuni decision, as you know, Yasuni is a national park, a biosphere reserve with, it is a hot spot, you name it. You know, the Yasuni is wonderful, pristine nature. The Ecuador decided to open up a little piece of Yasuni to oil exploitation, in the same momentum where rights of nature were emerging. So what happens is that the decision was made, and I'm just telling you, I'm not judging anything, because this topic it will be good for another webinar. But what happens is that the decision was made, and rights of nature were implemented in a way that environmental standards applied to this specific project were higher, were higher than normal or ordinary environmental standards. And regarding the respect of indigenous peoples that are present there or passing through the park, the decision was made in terms that oil exploitation could not take place in their territories. So in a way, that decision took notice. I'm not sure if best notice, but it took notice of the idea of rights of nature.
Yeah, well, thank you. I think, as you said, that's also a question of a whole new webinar, as Guillaume is beating me up here, saying that economic growth is not a human right. We have to, I guess, what we are here to and that what we are interested in is that rights of nature should challenge what we now call development.
Well, indeed, rights of nature does challenge the very concept of sustainable development. And this is something that we will see more often in the future. I mean, this is a substantive issue. You know, we are now, you know, sustainable development is a concept that everybody likes. The UN loves, the United Nations promotes, endorses, but at the end of the day, it is, you know, its practical applications sometimes do not favor the environmental side of development or society. So, but it is a standard that the world has chosen. And rights of nature, to be honest, is going to challenge that standard. It's designed to challenge that standard.
Exactly, which is why it's interesting.
In what ways, I really don't know. But this is the difference. You know, this is why I guess rights of nature are more effective in scenarios where in wildlife crime scenarios, for example, because what you are addressing there, illegal fisheries, for example, what you are addressing is already an infraction. It's something that is not permitted by law, whereas mining is. So it makes better sense to apply rights of nature in this type of contexts than in contexts that are promoted by sustainable development, whatever that means. Yeah, economic growth, that's another issue. Whether or not that's a human right is an entire whole debate that we have time to address.
Yeah, no. So let's move to a question from David. Thank you, Hugo. There have been interesting court decisions about the legal personhood of individual animals in Argentina and Colombia. Is anything similar happening in Ecuador that you're aware of?
Thanks for the question. It's no, the answer is no. And actually, leading scholars in Ecuador consider that rights of nature are not designed, and please follow me on this, and this is all very controversial in Ecuador. Rights of nature, according to leading opinion, is not designed to be applied for a species. It's designed to be applied for nature in a comprehensive way. Why they are making this differentiation, I really don't know. But basically what they say is that nature should be, when we talk about nature, we talk about an ecosystem, for example. But we cannot say the shark has rights or the jaguar has rights. And this has not yet, this topic has not yet reached any court. I guess the only ones that have been said something about that is been ourselves, for example, in the amicus curiae that I filed together with some other people. What we did is, we advocated for rights of nature in specifically for sharks. So, but this is not this is not the leading argument. The leading argument is that nature should be understood or interpreted as in comprehensive way. Yes, as David points out, Argentina and Colombia again are taking the lead. For example, granting habeas corpus to a bear and chimpanzees and primates. So this is it's interesting. Those cases are very interesting, and we can always talk about, because I have also followed those cases.
Okay, thank you, Hugo. I think actually I know that there are some other questions here, but the people who are asking them have already asked questions. So I wanted to have a question as well, and that's around the sort of the new decisions that you mentioned from India and New Zealand and Colombia. They are about specific parts of nature being proclaimed as legal subjects. So rivers, mountains, the Amazon. And that's another way of another strategy than Ecuador's, saying that nature in total, Pachamama, has rights. So what's your thought around that, I wonder?
Well, great question. Thank you for asking. Just to let you know, I'm running out of my battery, but if something happens, I will reconnect. Oh, no, thank you. No problem. Thank you. Okay. What was the question again? Sorry. I got distracted with...
Yeah, thank you for staying with us. It's about, so the pioneering decision of Ecuador is regarding nature in total, Pachamama even. But the decisions that we're seeing now is more about specific legal subjects. So taking out something, a river or a mountain or a forest, saying that this entity has rights. And that's sort of very different from what Ecuador did. So I was wondering if you have any thoughts on that.
Yes, okay, now I get it. Thanks. Well, the sense I get, not only in Colombia, with the cases in Colombia, but also in India, is that they are not necessarily taking the route that Ecuador did. They are rather, and I think this is a smarter strategy, to be honest, they are rather adapting an old concept that is universal in law, and that is legal personhood. So it is the same, it is a concept designed to recognize rights to human beings, but then it was also adapted to recognize rights to corporations, and now it's been adapted to recognize rights to other living objects. So by doing so, the courts, you have to remember that neither India nor Colombia recognizes rights to nature. Therefore, they have to play in a different scenario than the Ecuadorian one. And I guess what they have done is the way to go, meaning that you have this old concept and you adapt the old concept to a new reality. And this is why they can conclude that a river can have legal personhood, a mountain can have legal personhood, and a glacier can have legal personhood. It's because they are not dealing with Pachamama or with indigenous legal systems whatsoever. They are only using a traditional concept, an old concept, perfectly applied anywhere in any legal system. They are adapting this concept to a new reality. This is why I told you maybe the Ecuadorian case was the first one, but it might not be the best one. Like all first steps, you know, they need correction. And I guess what is happening in India and Colombia is actually showing the way to go regarding this topic.
Thank you. Thanks a lot. Yeah, it's so interesting that this is such an emergent space. And Hugo, I think we are all very, very grateful for everything you've given tonight and the work that you're doing in Ecuador. And I especially loved your very personal translations of the decisions that you presented. It's been truly delightful to listen to you. And this was the last webinar for this spring, but it's been great fun and a lot of learning. So I think I will try to do this after the summer even more. So please, if you have ideas or if you have something you want to present, don't hesitate to contact me. And for people who are in Stockholm, we will have another seminar on rights of nature and capitalism in May.
Pella, it's Robert. Yes, I don't know if you saw that I had still a question, but I didn't know when you were wanting to address it. But is there any time left for me to still ask it, or is it the time over now, or what would you say?
I would say that the time is up now. That's why I tried to wrap it up. There are several questions here.
If you saw the question that I tried to raise, but okay.
Yeah, I know, but you know, we are many people with a lot of questions. So please, you got Hugo's email address. So just contact him. He's also on Messenger, and you know that we are we all want the same thing. So we can make space for questions even in other contexts, right?
And we can always, before we leave, we can always have a second webinar in the future, because the message I want to leave you all is that please note that we are at the beginning of something. 10 years in legal terms is really, really not time. You know, it's very small time to conclude anything. There are several topics that are left pending, such as the relationship between development, growth, and nature. There is I see one question about that, very, very important. What we have to do is keep track of what is happening, not only in Ecuador, but all over the world regarding rights of nature, regarding legal personhood, and any new ideas that might come up for that matter. The time that we have invested here is just to show what has happened in the case of Ecuador, in cases that this has already put into practice before courts. This does not mean that what I have said is all there is to say to rights of nature. Of course, there are other perspectives. Not the only perspective I can give you is what what has happened when one goes to court and knocks on the door in order to get a judicial response on this topic. And to be honest, in 10 years to have several cases already for analysis is impressive, because the time, again, you know, in legal logic, 10 years is not really much. So yeah, okay, I just want to say thank you again for the invitation. I'll be happy to answer any questions that you may send via email. Please allow for some time for me to reply. And if we can ever meet to keep talking about this, I'll be happy to.
Thank you again, Hugo, so much. And thank you everyone for holding this space. Good night.
Good night.
From Sweden.
Good night.